All right. Uh, Good afternoon, everyone. My name is Moish Peltz. Thank you for joining us today at our Deep Bench Briefings webinar, the next one in our series, Identifying AI and Privacy Blind Spots Before They Become Liabilities. I'm here today with a very special guest, Steven Blickensderfer, who I'll allow him to introduce himself in a moment, as well as partners from our law firm, Jim Black, and associate Dan Gershman. We thank you all for joining us. And just before we get started, content here, views are the views of the participants in their individual capacity, not with any organization they belong to. And obviously, nothing is intended as legal or financial advice, but for informational purposes only. With that said, Steve, why don't you introduce yourself?
Hi, Moish. Thank you very much for having me today. Appreciate the invitation. As you mentioned, my name is Steve. I am a senior counsel in the privacy and AI team at Mastercard. Before that, I was at another company, a lead privacy counsel, their international publicly traded company. And before that, law firms. Among the beginning founding members of law firm's cyber and privacy practice group back in the day. Been doing this for a while. Looking forward to the conversation and happy to be participating today. So thanks so much.
Of course, thank you for joining us. And Jim, why don't you go next?
Sure. Jim Black. I'm a member of our corporate and securities group. I'm also a professor of compliance at Hofstra Law School, and I also am a delegate to the United Nations. My practice area is primarily regulatory and a lot of data privacy, getting more and more involved in our AI practice, and I'm also the firm's general counsel.
All right, thanks, Jim. And Dan, how about you?
All right, good afternoon, everyone. My name is Daniel Gershman. I'm one of the associates of the corporate and securities group of Falcon Rapport and Berkman. I'm also a member of the digital assets, cannabis, labor and employment, IP, and tax departments as well. Almost anything that's not litigation. I focus mainly on compliance. Right now, it's delving into data privacy and AI.
All right, fantastic. So I want to set the stage a little bit for, the theme of today, which really is around, I think we have a really excellent panel today with vantage points on AI governance, data privacy, something we're all thinking about a lot. And many organizations either believe they have adequate privacy or AI controls in place, but I think are either knowingly or unknowingly seeing that there are a lot of gaps in these policies, and that's because I think that there are one everything in AI is moving so quickly. So if you had everything covered 3 months ago, the world has changed, and now we're in an agentic future. And so if you haven't addressed that in all your policies, well, maybe your policies are outdated. And then as it relates to vendors, employees, consumers, internal governance. It's just everything's moving very quickly. And our view, at the firm at least, is that there's a lot of blind spots that need to be increasingly addressed with velocity. So that's what we wanted to talk about today. And so, maybe we can just start off with the panel. Across your vantage, where do you see the state of the market today, and the readiness for organizations with AI and privacy? Steve, let's start with you.
Uh, well, to maybe start things off, I see this general trend of just AI kind of being added on to privacy functions and just within the scope of work there. Also, just it's kind of evolving into this more data usage, data governance framework. So broadening out beyond just a privacy, as a silo term. AI has been part of that. Cyber is naturally also part of that. So this kind of just how data is used as it's come in, whether it should even come in, um, assessments that should be conducted, whether it's AI related or privacy related. Um, it, there's kind of this is attaching AI onto it and merging it to kind of together to form this just kind of larger view of what data governance means. And I kind of do see that as a trend of more companies just kind of moving in that direction. You rarely will get these days, maybe a client coming to you saying, "Oh, I just need you to update a privacy policy." It's more than that, and I think that's just a sign of just where everybody is and how they're trying to address the regulatory and compliance challenges that come with these new laws.
Yeah, I think that's exactly right. It's if you're just thinking about the policy and you're missing the larger, big tent privacy and data kind of. I didn't mean it narrowly. I think you're right. It is this larger sphere, but you're not thinking of a larger governance question and how this is an ongoing process versus a static document. Then you're missing the forest for the trees. Jim, what are you seeing?
Yeah, I would completely agree with that. I think you've got a situation here where it's interesting that the Europeans have always looked at this as the concept of compliance by design. And I think what we're seeing now is a much greater, as Steve said, holistic view of the use of data. It's not just a privacy issue. It's not just an AI issue. It's not just a cyber issue. It's all of it together in one larger, again, I would say, holistic view of the use of corporate data, personal data, how it's stored, where it's used. And AI is just another tool. People worry about AI is going to take over our lives, not if we don't let it, but it is this concept of at being a tool. It's a very strong tool, but we have to be a tool is dangerous if it's dropped by the person using it. So the people using it have to hold on tight to it, no differently than you hold on to an electric saw. And I think that this is really going to end up overall that companies, as they start to develop, and I think maybe Steve might be a little bit more optimistic than I am. Again, some of the bigger companies, of course, know what they have to do, but the medium-sized companies, the smaller companies, they were slow on data privacy, especially in the US. And I think you're going to see some development of AI. I'm afraid some people are going to be once burned, twice shy on how to be able to protect themselves and how to be able to monitor their own use. But again, just to summarize, I think you're going to see a broad, holistic view of how data is used and protected.
All right. So our next discussion point is about aligning vendor agreements with internal privacy policies. So I guess maybe Dan, is something I know you work a lot on, is about, you know, vendor agreements and how those relate to established privacy policies. So what are you seeing and where do you often see misalignment or just practical gaps that need to be filled?
So a lot of times when it comes to negotiating these types of agreements, and especially as a practitioner in this field where we have companies that are entering into these vendor agreements, the most common misalignment is the use of like the restrictions on data use. So a company's privacy policy that a lot of companies have on their website, they tell customers what they do with their data and how it will be used. It will be similar language of the data will be used to help with the services that you've requested from us. But in the vendor agreements themselves, it allows for the vendor to use either aggregated or de-identified data for its own product improvement, for its own benchmarking, even for its own model training. And these are where certain misalignments can come into play of whether that data is truly aggregated or whether it can tie back to an actual customer base. Another frequent gap involves sub-processors or international cross-border data transfer mechanisms. So your privacy policy has a very limited control of who controls that data, who has access to it. But normally what we see in vendor contracts is unlimited sub-processor delegation, normally with either no notice or no approval right over that. So that's one of the things that we jump in when we're negotiating these vendor agreements to say, hey, you can only list your sub-processors that are listed in advance. If you change these, you need to provide us advance notice. And a lot of times you want to involve those sub-processors being held to the same confidentiality standards that you are going to hold the ultimate vendor itself. And then cross-border comes into play. A lot of times when you have vendors who are entering into data agreements and they're immediately shipping that data across border. And that brings in a lot of other regulatory enforcement under state privacy laws, under the GDPR that Jim mentioned before. And all of these can tie back to open liabilities to the end user, which is the data controller.
And just to add to what Dan said for 1 second, I think a lot of people lose sight of that. They don't necessarily look very deeply into that part of their vendor agreements. Also, because I think I see it, I'm sure I'd love to hear Steve's thought on this. A lot more vendors simply give you a link and say, "Here, I have clients go, oh, it's only a one-page agreement," and you go to the link and it's a 30-page document with all the pitfalls and issues that Dan mentions. And I think there's a new level of obligation on people, especially if you are depending on your customer facing world with your vendors, to make sure that your vendors are aligned to your policies and procedures and the representation you make to your clients, because you're going to be held accountable for whatever they do.
Yeah, to jump in there, third-party risk management, which is where vendors and reviewing them fits, is a big part of just overall compliance. And it's an area where folks can make a big impact, especially if contracts flow through legal and, maybe privacy sits in legal or I'm gonna say privacy as the old term, but data, governance sits in legal, and you can be a help here. Uh, to Jim's point, there increasingly are contracts that are links, and they're governing not just. I mean, as consumers, we're used to seeing that. To advance to the platform, you must agree to the terms, and you acknowledge the privacy policy. Click here. You're also starting to see that more increasingly on the commercial side. And so there's just a way, it's just another format of having a contract presented to you, and whether or not you can negotiate it is the first question to be considering, and also to make sure your business teams are aware that when they're looking to get access to a platform or a system, if they're acknowledging and checking boxes along the way to get platform access to maybe test something out, they're agreeing to things, and they might be binding you to things that you need to be aware of in advance. So it's important to get ahead of that if you can. I sometimes it's just playing catch up, but it's important to just be aware of the various different ways that these contracts can be presented to the company, or the company could enter into contracts. And just online contracts is an increasing, risk area, just how easy it is to enter into them. So
And again, I think this comes down to policy and procedure, and really, I would say more procedure and practice. Everybody has these great written policies somewhere. How much do they follow them and really know? And does everyone know what they say? So I think it's important to really have a practice, and maybe to work, especially if you have a vendor group or a procurement group, or if not, whoever handles it in the company, to make sure that there is a list of checkoff things to look at ahead of time. If you can review a contract, just like we train our associates, procurement should be trained the same way. If you're going to review a contract, look for these issues, because they're business issues that you need to address. And look, some vendors are going to be like, take it or leave it. This is what I got. And then there's no escalation process. But I think it's good practice for clients to understand, look, these are the things that I need to look for even before I hand them over to a lawyer. Definitely hand them over to a lawyer, but but these are some of the things I think they need to look at themselves.
Yeah,
Well,
I
then
think to
there's,
jump off
go ahead, Dan.
to jump off Jim's point, a lot of the companies that manage this well have that vendor intake process that includes the check the box things of certain highlighted terms of your billing, 30-day net processing, but includes these data privacy, data security, and the data processing as highlighted things that they need to spot.
Yeah, and then I was going to ask about two specific types of agreements. One of which is a legacy vendor agreement that doesn't contemplate AI, but is now, as the relationship between you and that vendor continues, necessarily involves AI to some degree. And so, how do you think about that? And then I think the flip side of that is in procuring AI specific vendors, and now you're contemplating privacy commitments, explicitly including the use of AI. And I think both agreements present different types of issues. So I'm curious how you think through those two issues. Right? Is I'm doing increasingly AI work with the vendor pursuant to an agreement that has no contemplation of AI. Does it matter? Does the fact that it's AI change the function of the agreement or not? It's just something that needs to be reanalyzed given the current context and evolution of the relationship, or something scarier? And then when you're negotiating specifically for the use of, as an example, customer data in a third party AI tool, what sorts of issues come up there? I don't know who wants to kick us off here.
Well,
So
well,
I can
also,
probably
well, I
go.
was just gonna just to start off by saying all those questions are important. All those kind of different variations matter, but you don't know everything just based off of the paper, right? And oftentimes the paper, may even just misrepresent kind of what everybody understands the relationship to be. And then you get to the paper and it's like, I don't understand what the things are that we need to be looking out for because I don't know enough about what this is, how we're going to use it, what data is flowing through it, so on and so forth. AI is a form of processing if you think about it at
Mhm.
bottom. And so if you're not fully appreciating how this product, AI processing is a feature or a byproduct or a sideshow of this. Um, you don't know unless you gather enough information up front. So, spoken like a true general counsel, Jim's like, you need a checklist, right? Yeah, you need checklists are great as in-house counsel. I mean, that's just kind of how the world runs. And I very quickly found myself like by the third contract I was reviewing for privacy, realized I need a checklist because I keep asking the same questions.
Mhm.
And if I can, offboard that to the business side to maybe answer these before they come to legal or privacy, that would save a lot of time.
Well,
But no, so yeah, so the point there being getting the context is key before you can even answer a lot of those questions.
exactly. Yeah. Well, Steve, by the way, I don't know if I mentioned, of the 39 years of practicing law, about 36 of those I was in-house counsel. So
There you go.
34 of those I
Comes
was
through.
in. So yeah. Yes. So I feel it definitely. But back to Moish's question, I think just to make it even harder on people is that, yeah, it's not in our contract, but what we did in one of the companies I was GC for years ago in the days of Y2K, if we some of you might remember all of that, we proactively just put out addendums to our contracts and said, this is how we it was a large software company. This is how we handle the Y2K issue. This is why it's a non-issue. Go away and don't bother me with your 37-page Y2K addendum. I don't know if I think Moish, Steve, you guys weren't practicing back in 1999 and 2000, but it was a cottage industry for lawyers. And I feel that the same thing could happen with data privacy, with AI. It's like, oh, we're going to make a big deal out of this, but I think these things are much bigger deals because the regulations have teeth. The regulations have fines. Um, in the area of data privacy, for people who do things internationally, Japan had the ultimate hold my beer moment, and there's criminal liability for data privacy violations. So again, my point being that there's really a need, I think, to get proactive with contracts that don't have provisions on AI or even privacy, and maybe come up, if you can, with an addendum to your vendors and say, look, we're amending our contract with you because we need to be compliant, and if for us to be compliant, you have to be compliant. I know that's a heavy lift, and every GC on here just cringed, but it's been there, done that. I got the T-shirt, the coffee mug, and the sweatshirt. You really do need to do it because if you don't, you could end up on the wrong side of a new regulation, on the wrong side of a customer complaint. So,
I think touching on what both Steve and Jim mentioned, I think the first step when it comes to legacy contracts is honestly triage. Um, Repping on the vendor side versus the service recipient side, we include provisions that you can delegate your services to sub-processors or third-party services, and that is where the AI services come into play. So whether it's fully integrated as AI-specific language, that language is already in almost all of these sub-processor agreements. And the worst outcome that you could possibly do as a GC is just leaving legacy agreements untouched and hope that no one noticed. So one of the things that we recommend companies do is issuing a formal inquiry. Hey, are you using AI services in providing your services? If so, how is it being used? What policies are in place to help protect this data and its use within AI? And then moving from there is once we actually identify the source issue that is at hand, then thinking about negotiating an amendment or adding addenda to the agreement.
All right. So moving on to our next topic, which I think is probably one of the largest blind spots, is employee use of shadow IT, and that is, or shadow AI for that matter. And that's, as an organization, you spend a lot of time, energy, and money, you know, procuring new tools, whether AI or otherwise, rolling them out to employees, training them on them, and then it turns out, the employee just says, "Well, I like using the free version of ChatGPT on my phone anyways because that's easier or quicker to access, or maybe even better than the company provided tools." And so I think it's hard to know from a organizational perspective, well, if a person in your organization is using a tool on an unapproved device that you don't know about, how do you police that? And it's even worse than if they're putting sensitive company data, perhaps sensitive customer data that would otherwise be subject to the data privacy protections we've talked about earlier, into these systems. So I think this is a huge problem because there's huge potential for leakage and for undermining all the hard work that we do to set up companies for success, and ultimately exposes the organization to unexpected risk and regulatory scrutiny. So, to the panel, how do we define this shadow usage in the context of AI? And is this a problem you think that organizations have a decent grip on, or is it, as I'm theorizing, actually a pretty large problem? And then what do we do from here? So, Steve, I'll start with you.
I I guess everyone's kind of likening AI usage to like when the internet first came out, right? So if you can
Yeah,
imagine you have a you have a you have a companies racing to establish governance programs, rules. These are the tools. They're testing tools. They're replacing tools. And then at the same time, some companies encouraging employees to use it. And then you have just this temptation to just use what's available or maybe what you're on the weekends testing out. It's an important for so basically kind of going back to the internet metaphor, it's like telling employees here are the approved browsers you can use, and you have to log in through a VPN, like extra steps that it's just like putting those restrictions and barriers why they're necessary. It's natural to understand why the shadow use comes up, but it's important to bring awareness to the potential risks and real risks that are caused by it. So it's like you're trying to get in front of it, and you have just these holes that are created by usage that I think it's just that education and awareness can really help here. And just the checklist process on the front end, making sure that folks are aware of what the rules are, aware of why they're in place, because there are just every day you look on the news and there's just a new reason for why something exists, a rule or a plan with respect to this issue exists. Um, it's hard. It's like sometimes can be like a game of whack-a-mole, it feels, to make sure you're kind of getting in front of it. And I think there has to be a risk appetite. How much is the company kind of all in on AI? How much of it is locked down? What industry are you in? Are you sensitive to how your company's tech is being used and devices are being used? Kind of, it's an opportunity to kind of check on all of those things. And if you're really weak or not so much weak, but just like not paying as much attention to those issues, you're finding yourself struggling potentially with catching up on some of these things. So I think just overall awareness and just kind of putting up not like gates per se, but like checkpoints to make sure folks are aware and not making it too difficult. Because then you're just going to make it very easy for folks to want to just use their own tech. So I think it's a combination of things and a touch and depends on who you are and what you're trying to do.
Well,
yeah.
I
There's
would.
also an element of practicality here. Of you know, some of these tools are just so novel and so beneficial to workflows that saying you can't use them will stifle employees, and like they're going to do it anyways, or they're going to try and find a way to do it. And so it's like, well, how do we, maybe there's a more positive outlook here too, of like, how do we enable employees to use the novel tools more quickly? And I think that goes back to, if you have good governance and you have the ability to quickly vet and onboard new tools, then it solves the problem versus just playing whack-a-mole, right?
Right.
Well, I'm gonna be the old guy on the call for a minute. This is really tale as old as time. I remember, again, working for various technology companies over the years, where, software engineers, and some of my best friends are software engineers, but they would find this new tool, and it was not an approved tool. We didn't have a license for this tool. The tool may or may not have had back doors to it, but they started using it and designing the company software because it was cool and it was better and it was faster. Um, AI is just another um, symptom or tool that people use. And Moish is exactly right. It really is a question of governance, and it really is a question of because I had IT directors come to me all the time and going, I don't know how this got into our system. We've got this massive malware problem, and you track it down, and John one day, found this great app or this great tool, and he just started using it on his company computer, and all hell broke loose. AI is just another variation of, I think, of that issue. But again, Moish is exactly right. It really is a question of governance and explaining to people that, yeah, we want you to be innovative, but it's not the wild, wild west. I think it's back to, did we mention policy, procedures, and practices?
I think what was touched on by both Steve and Jim, it really ties back to education. Speaking with other associates at the law firm, speaking with other friends who work in other industries, a lot of employees who are using AI, it's no malicious intent. It's trying to get the work done faster, trying to get it done smarter and more efficient. So they're trying to use AI as exactly that, another tool to get the job done. But it really falls on the onus of the company to educate their workforce of the risks and liabilities with using unvetted AI and what it's doing with that data that you put in. If you're an employee and you're just trying to put in data to help you get your workflows done faster, you're uploading without knowing confidential information, client information, proprietary information, and without knowing, you don't know what that free AI software is doing with that information on the back end. And that risks the company being exposed to confidentiality or contract breaches with its underlying client base that it's now using their information and it just ported it online without their knowledge.
Mhm.
Yeah, and I think also from the small to medium size organization, from the tech startup organization, like the flip side of this is when you're building a product, we have a lot of clients in this position that their whole go-to-market strategy is like a bottom-up sales strategy, right? It's getting, the product in the hands of like individual employees, having the enterprise get a taste of how good that is, and then like expanding it from one or two or three employees to, a full team or a full organization. I think like Slack, for example, is one of these. They're like that was their entire initial go-to-market strategy, and like how they got so much traction was like they just beat, Microsoft Teams or whatever it was by like being, bottom up kind of adopted. So I think from the flip side of this is like understanding the corporate controls and like the gating process that's happening, and then working to provide, your customers, both on the individual and then ultimately the enterprise level, the tools they need to successfully get on board into a company. So I think it kind of goes both ways, right?
Yeah, I think that's very true. And look, it's always a balance between whether you're dealing with the sales teams, whether you're dealing with the development teams. It's the software company I was at, they called the GCs sales prevention, because we were always trying to slow things down. But in both instances, it comes back to one of the things I say in my class is that sort of you want to do the right things in the right ways for the right reasons. And while that's got higher implications, it's got also implications in when you're doing development, when you're doing sales, just to make sure that one sale doesn't jeopardize the rest of the company, or one bit of one, really want to get this piece of development done quicker and cooler and better doesn't harm the greater infrastructure of what you're working on.
Yeah. So I guess the follow-up question there is, is there any, to maybe pick on some old guy wisdom, Jim, is there any meaningful difference between, this happening in the 90s .com era of an employee using a personal email account or, a personal device versus now an unapproved AI tool. I mean, is there a meaningful difference? Does the fact that it's AI and it's new and novel and scary, uh, actually is this just the same risk repackaged with new technology, or is this, really like we're in kind of a new era of data risks that just haven't uh, come around before?
Well, I think it's in many ways it's the old risk, but it's magnified because of what AI can do, and because the fact AI learned and it just, you know, AI is almost like is, if I may be so rude, is like a face hugger. It just absorbs things out of you, and you don't even know about it if you're using OpenAI. I think it's the same concern, the same problem, but it's magnified because of social media, of the much faster use of data, the much faster absorption of data, and the much greater areas where your data can go. So it's fundamentally the same issue of keeping everybody sort of on side, but I think now the ramifications are much greater and much more dangerous. And last point is now there's legislation in which you can be fined for these errors.
Yeah, I think it's a great point. It's just there's also much more data moving around with much more velocity.
Hmm.
And so when things go wrong, the screw ups can just be bigger, right?
Right. When they go wrong, they can be faster and bigger and harder to catch.
With regulatory implications.
Yes, exactly.
How fun.
But other than that, it's all good.
All right. Moving on to our next topic. Um, we wanted to talk about identifying gaps between data practices and what is actually publicly disclosed by a company. Steve, this was a topic that you mentioned earlier of, well, I'm reading the agreement. I'm not sure if the agreement makes much sense, but then I go and talk to the business team that actually is trying to do the thing. It's like, oh, that's a completely different, you know, objective than what is written in the agreement. I think the same issue is, public data disclosures, data privacy policies might say one thing, might promise one thing, might commit to one thing, but in reality, something else is happening differently under the hood. And that could be from, there's a contractual commitment to AI models not training on your data, but in fact they are, or in fact there's some other analytics or profile or other, machine learning happening that may not be explicitly, AI model training. So how should companies think about, um, addressing that potential risk of uh, disclosure versus the real underlying practices, and then how does that relate to the emerging regulatory framework about governance and risk factors there?
If you go back to the privacy fundamentals, one of the key pillars is transparency and accountability. So you want to be transparent with what you're doing about data. And let's face it, not all companies are transparent in what they're doing about data. And so that's just something to just be aware of when you are reviewing a vendor, when you are reviewing a contract, who's on the other side. And sometimes it's just a matter of kind of Google searching who they are. I've found statements on YouTube that CEOs of companies that we were entering into contracts with were saying what they were going to do with data. That wasn't, it was not consistent with what I was seeing in terms of other representation. So you never know what you're going to find by just do basic searching. Um, but in addition to just being transparent, you also need to be accountable. You need to have, and how do you be accountable? You have documentation that supports what you're saying, supports what you're representing. And when those things don't line up, that's when you run into problems with misrepresentations. And that's, we talked about there are increasing laws. Everybody knows that they're there, that they're continuing to be enforced. And we haven't mentioned, enforcement actions quite yet, but the FTC in the U.S. side, the European regulators on the European side, regulators in Asia. I mean, everyone's looking for this stuff and reacting sometimes to complaints from consumers. So you just have to be prepared for that, and you don't want to be at the helm and unprepared to be able to support what you're doing. Um, when you had a chance to fix it at the beginning, at the outset. So it's kind of just something to mindful of? And how can you start that process? Well, it starts by documenting what exists, um, assessing activities, creating records of processing activities, and um, and figuring out if there's like a new contract. Is it revealing new processing activity that's not quite captured in a ROPA that you already have? Like all of this stuff builds on each other and serves a purpose of, okay, now when we're representing what we're doing, is it consistent with the documentation that we've established so that we could be accountable? So I just when the question just naturally made me think of those principles that underlie, global privacy standards and laws that we have, and they drive the reasons why regulators sometimes are so, going after companies is that they see this misrepresentation, or they've called out somebody that can't document and support what they're saying, and then they'll run into issues.
Yeah, and I think that's true. I mean, one of the issues for the FTC is they have very few tools, very few arrows in the quiver that they can use. But one of them is that if is misrepresentation, and they are, well, I don't know how aggressive they are in the last year or so, but prior to that, they were relatively aggressive in the fact that if you had a misrepresentation and you didn't live up, it's the old hoisted on your own petard kind of a rule, and that was what they would go after. That if you didn't live up to your privacy policies and you didn't live up to your other representations, they were going to fine you. And in some areas, in some states, um, there's private right of action both in the data privacy and other areas, which, and no offense to the plaintiff's lawyers, but it's a plaintiff's lawyer's dream now. And that's always the fight when these new state data privacy laws come in that, that Dan and I are watching almost on the weekly is, are there private rights of action, or are the attorneys general keeping the enforcement in their own hands?
Yeah, I guess to dovetail right off of what Jim was saying is like we're now seeing the FTC, the state's attorney generals, or in states like California and under the CCPA, the private right of action, and agencies under the FTC view this as the classic bait and switch of if you're having a data privacy policy, this is one thing, and what you're actually doing with it is the exact other. And to tie back to the initial question at this presentation of where is there's misalignment, and it's companies that pretty much say, "Oh, I have a privacy policy, I'm covered." But it hasn't been updated to really show what you are truly doing with the data. And as AI has been accelerating and how data is being collected, how it's being processed, and how it's being repurposed is key to really showing to your customer base what you're actually doing with that data.
And back to what we said before, what are you doing with it, and what are your vendors doing with it?
Yep.
Yeah, I think that's great on the, just going back to first principles of both transparency and accountability. And I think that's right. I think, Steve, what you mentioned also is like there's a bit of practicality here of, knowing the people you're getting into business with, and knowing, taking that extra step to look beyond just what's in the document, and like, can you go meet them? Can you go shake their hand? Can you look on their YouTube profile, or see like I've seen investor documents that say, hey, here's how we're going to monetize, data, things like that might be inconsistent with public stances. And then even just last month, right? I mean, a lot of people talk about, oh, do they have their SOC 2? But there was a big scandal about one of these kind of like on-demand SOC 2 companies actually just saying, well, we kind of just are just kind of give everyone a document if they check a box. We don't actually do any of the, real under the hood searching to see if they've actually qualified for those types of standards. So it's less about whether they check the box and more about, the real kind of accountability, the real transparency,
Hmm.
kind of
Yeah,
human relationships here.
and there's kind of like two parts to being accountable. There's this I view them as like internal policies and external policies. So the external policies are like the privacy policy that we just referenced. It's what you're stating to the world, what regulators can go on your website and find. Maybe you'll have facts page about GDPR compliance or whatever. Then you have internal policies. And oftentimes the internal policies get the least attention because it's like, hey, who's going to look at these? But it's important to realize how much that kind of sets the tone for the business. If you don't have, if you're not paying much attention to it, you're not dedicating resources to it, it's going to be an afterthought. And so I found that the stronger those can be, the internal policy that governs a company and sets a standard for this is why we're going to do these things. This is what we're doing to advance this policy, and this is how we're going to keep ourselves honest in terms of checking and auditing, on a go forward basis. And that will maybe make your audit or your certification process easier down the road or whatever. But naturally, the idea is that that won't see the light of day, and it's really just for the business. But I think it's important to understand that it's from that seed that you're planting in that internal policy that you're going to be able to build out the other parts of the program that helps to govern
Mhm.
the handling of data, the review of vendors, all the things we're talking about. It can kind of stem back to these internal set of documents that, like anything else, it starts with what's our stance on this, how are we going to approach it, and if you don't have it written down, it can be ad hoc. You could be just kind of Wild West risky, just taking whatever comes in, and how did you handle it last time? You don't know. You're spinning up, trying to figure it out, dig through emails. It could be quite cumbersome. So to avoid that, a little bit of effort, today, tomorrow you'll be able to save some hopefully and see some efficiencies later. So it's, and it's not one size fits all for every company. It's going to be what's your risk appetite? What are you willing to commit to today? What resources do you have? You have to be able to sell to other business folks like, hey, we need to spend some time and money here so we can get this right, so we can set a good standard, going forward. If you miss the privacy boat, you do it right now at AI. If you miss the AI boat, well, I don't know what's behind it, but it's probably going to be another opportunity, maybe, but you should do it now.
Yeah. And by the way, to Steve's point, back to the fact that different jurisdictions are enforcing this concept of compliance by design, those internal policies will very quickly become subject of conversation with regulators. Because if that is exactly what they will say, because I talk about this in my class as well and with clients, is that it can't be a check off the box culture. It can't be a check off the box process. You do need to check off those boxes, but again, it's part of a larger process. Because if you get a customer complaint or a client complaint or a consumer complaint in the jurisdictions that have compliance by design, which is California, all of Europe, Korea, Japan, Saudi Arabia, by the way, they're going to be looking at that and they're going to say, all right, we want to know privacy by design. Show us your internal policies and procedures and practices. So to Steve's point, they they will very quickly come to the forefront of discussion. So they need to be there and they need to be right.
Yeah, and Jim, you were talking about before another layer of risk related to securities law risks, where public companies, I guess the question is, are they adequately disclosing AI privacy related risks in their public filings, or is that another risk factor for additional either public or private enforcement and litigation about those inefficient disclosures?
Oh, absolutely. I mean, again, uh, this is just today's issue. I mean, I've joked before that data privacy is the modern pothole. Back when I was a very young lawyer, there were these lawyers who'd go around New York City and register every pothole with the state, so they would have a year and 90 days to sue. And this is the exact same thing. Plaintiffs' lawyers are going to be scouring. Plaintiffs' lawyers are going to try to ping and see whether there's a privacy or an AI violation. And if there's a state statute, they'll do that. If it's a public company, you're exactly right, Moish. You'll get some sort of a shareholder derivative suit saying that they're not following procedure, they're not properly disclosing in their 10Qs or their 10Ks.
All right, so we've talked a lot about the risks here. Switching gears a bit to how we can overcome those risks and what we can do to strengthen governance around AI and data usage. So, Jim, let's start with you. What does a mature AI governance framework look like in both in theory and in practice, and how does that differ from, how it may have looked a few years ago before AI became a buzzword?
Well, I think a few years ago people didn't think about AI, just like a few years before that people didn't think about privacy. But I think my point, I would say that in the theory and practice need to be pretty much aligned. You can have gold standard, not gold standard, but I think you need a robust privacy policy and AI policy that is clearly articulated, clearly understandable, and pretty strictly enforced. You never want to do the harsh thing and give the ultimate issue to someone who violates policies. That's never fun. But it's also not fun for that violation could to cause a company to face significant litigation or regulatory fines. So I think again, it's got to be clear, concise, up to date, which is hard because the rules are consistently changing, um, enforceable, and enforced.
So, Steve, same question to you. What does good governance look like?
I think it starts with knowing you have kind of multiple facets. It starts with knowledge, right? Like, what are you doing with it? What do you want to be doing with it? Kind of some policy decisions need to be set forth, and put in and record that. Also have to have a knowing and a knowledge of how do you want to approach it from a people's perspective. You probably need someone to own it and to govern it. You maybe set up a team. Is this team going to exist in another team and kind of figure that stuff out? And then start to then have that team set forth in motion just what we've been talking about this entire time. I think all that is important in order to kind of get this process started, whether you attach it to a governance structure that's already in place or spin off a new one, which is kind of more common. They kind of exist in parallel, maybe report up in the same way at some point. But yeah, I think you need to start with if no one's there and responsible for it, it gets harder to establish practices and procedures that we've been discussing, because just everyone's going to point the finger at someone else or say it wasn't me, it's not my responsibility. So getting those R&Rs locked down, I think, is one of the first steps to getting this process started.
Yeah, I'm going to jump in what Steve said about that because that's an important point, not just for this, but in governance generally, is the concept between responsibility and accountability. Um, if the worst thing you want to have is the committee that says we're all in this together, we're all responsible. That's a lovely buzzword, but it means no one's doing anything. So there has to be specific accountability. Specific people have to receive specific jobs and specific obligations and come back and say, okay, I did my piece, so that the sum does, that the sum does become greater than the whole becomes greater than the sum of the parts. But each of those parts, someone has to be responsible for writing the policy, checking the vendors, as Steve said, doing the due diligence on the vendors. And he makes an excellent point. It's in many ways it's no different doing due diligence on vendors today and AI than we would do years ago when we were doing um, consultants from overseas and making for that lovely old statute that's not enforced right now, the Foreign Corrupt Practices Act, and finding out what people did. So I think Steve's right on point about that.
Yeah, I think that dovetails really nicely with some of the, you know, AI specific, but not even just data privacy, risk management frameworks. I'm thinking of the NIST AI risk management framework, for example, which has the govern, map, manage, measure, manage kind of steps, and baked into all those steps. If someone out there in the audience wants to, get more of a, how do you package all this together and assign accountability and make sure that those risks are managed and someone's responsible for that. I think it's, you don't need to start from scratch, right? There are frameworks out there that help devise that. Just needs to be adapted to the organization, and someone needs to be designated as, you are responsible for this outcome and for making this process move, whether that's a formal and dedicated AI governance committee or whether it's part of some other compliance structure. Obviously that function needs to be happening.
Right. And by the way, I would say this small and medium-sized businesses should not be afraid to outsource that. That exists in data privacy, especially in Europe, when there was personal liability for DPOs. A lot of people in companies went, unless you're a really large company, no one wanted to be the DPO. And there's this cottage industry of lawyers and compliance people that a big German firm that I worked with for years. Went to reach out to one of the senior associates, like, oh no, she's gone. She's formed an outsourced DPO business. So look, when it's a small, medium-sized business, it's like, oh my gosh, who's going to do this as well as doing everything else because everyone's doing 12 jobs already. The obligation doesn't go away. It's a cost, but it's pennies now, dollars later. So that would be the other thing, is to find an outsourced entity to do that. Like Steve's company is big enough, they don't need to do that, but small and medium-sized companies absolutely should think about it because they just can't find themselves, oh, we didn't, no one's going to accept the fact that, oh, we didn't get around to it, or we didn't have the bandwidth to do it. That will not be a colorable defense.
So moving on to our final topic, which I think is a nice segue from what you were just discussing, Jim, is what are the kind of simple, proactive next steps that someone can take? Whether it's a board of directors or management of a company, and they look around and they say, I just listened to FRB's Deep Bench podcast, and I'm not thinking about any of that. What should I do next? Or do I even get started? This is just moving very quickly. So what are the practical next steps that someone can take to get started in this space?
I think it's a lot of things we talked about. Is that find out who your vendors are, what are your agreements with your vendors, get policies in place, who's using AI. If you don't have an enterprise locked version, get one. I think, and I've been waiting for the chance to say this. With all due respect to the open AI, the chat GPTs of the world, use it at your peril. And if anyone in a company uses it, I think they're a little crazy because they're just creating really, really great risks for themselves because that stuff can learn and absorb, especially depending what data you're putting in. So I think it's important if you're going to use AI, get an enterprise closed version that doesn't learn and doesn't share. And just take the time to understand, and Steve made a good point about this before, understand the practicalities of your business. Just like contracts are supposed to reflect business deals, policies, procedures, and practices are supposed to reflect what the company's doing. They've got to make sure and inform it that it does it the right way. But I think that those are the basic tools. And I think Dan mentions for us education. Understand what we're doing, understand where the risks are, and then create process and procedures and documentation to eliminate or mitigate the risks.
Yeah,
So Dan, how about you? Yeah.
go ahead, Dan.
Yeah, to dovetail right off of what Jim was saying, I think that the easiest thing that anyone can leave this meeting and immediately take back is conducting an AI inventory, even an imperfect one. Just asking your business units three questions. What AI are you using? What data is being put into it? And did legal or IT approve it? And the answers to these will most certainly reveal the blind spot, the gaps. They'll reveal the tools and data flows that leadership didn't know about. And essentially, going back to education is you can't manage what you don't know. And those three questions will vastly show what data is being used and what vendors are being provided.
All
Yeah,
right, Steve.
I was going to mention the same thing. If anything, I could add that inventory typically will then turn into a list of approved tools. Once you
Yep.
get past that point of asking everybody and you've done that first wave, then the next thing is that turns into, all right, here's our list of approved tools. And then you got to think about how you're going to keep that up to date. Because, I mean, we all know this stuff happens and progresses so quickly. There tends to be a fatigue that sets in where it's like, okay, this tool set, when was the last time it was looked at? Well, you have to think about how you're going to keep it up to date because all that effort you went into putting it together could be lost if you're not keeping it current. So keep that in mind as well.
And back to what I was saying before, that was exactly how in some of the tech companies I was in, we tackled the issues of using the latest and greatest, but untested and unapproved apps. It really is the same sort of a process of just making sure of doing that. So people should be a little familiar when those questions and requirements come down.
Okay. And I think we're nearing the end of our time here. So if there's any other questions from the audience, feel free to get them in now. Otherwise, Steve, maybe we'll go you, then Jim, then Dan. Just final words for the audience.
I always try to be practical in how I'm speaking on these topics, and speaking about policies, procedures can sometimes feel overwhelming. So if anything, my takeaway is more leaning towards how do you start that process of establishing something. And I think you can start with an outline of a plan to address this, whether you're focused on AI or you're broader to be like data governance. Then document the actions that you take in pursuing that plan, create those checklists for repeat activities and tasks, filter what needs to be assessed through those checklists. Hopefully have one that asks questions that then ties into, whether you need to do assessments from there. And then before you know it, you're off and running. You've actually started to document parts of the governance process and procedure, and then just make improvements from there. But hopefully that helps folks get started, because sometimes that's the hardest part.
Mhm. I would agree with everything Steve said. My only add on to that would be, as far as getting started, get started. Time is of the essence.
Yeah, I guess to dovetail right off of what Jim mentioned, the easiest takeaway from this call is just to ask yourself, where is AI touching your data? And if you can't answer that question immediately, there's your blind spot, because AI is touching it in one way or another, whether it's through your vendors, whether it's through your employees, through an adequate approved AI, or if it's through shadow AI, it's being used. So how are you protecting yourself?
Hmm.
All right. Well, Steve, thank you so much for joining us today. We really, really appreciate it. And thank you all in the audience for joining as well. We certainly appreciate you coming by. And of course, if you have any questions, we'll include with the recap our contact information, and feel free to reach out if there's anything we can do to help you on your journey of data and AI risks. All right. Well, thank you all. Enjoy the rest of your day. Appreciate it.
Take care.
Thank you, everybody.
Thank you.